and whether he was the last person to be seen with the deceased. Now, considering the evidence of PW7, Lee Owen, his evidence is that the first accused person was in the deceased house. Waridi did not testify, and nothing much can follow on his evidence if he has not been tested on it. But the strongest argument the accused person is advancing is that, look, there were these two other male persons. First of all, there were other people, the Akina Waridis, the Lee Owens, the Kakas. Why were they not also investigated? But he advances another argument. The strappings that were used to tie the deceased, the evidence of the government analyst is that it revealed DNA of two unknown males. These are the people who were in that house, and that Dominic Harron. Allow me to make my observation. But before I do that, back to Lee Owen. You know, Lee Owen is the witness who says, I was with the first accused person. And I needed to find out, why is the first accused person in the deceased house for over 1 hour? That was his evidence. Secondly, the first accused person was using coded language. Thirdly, he had a beard. And fourthly, he had brownish eyes. Then he says, in their conversation with the first accused person on that day, these are the words the first accused person said, and I'll quote, that in their conversation with the first accused person in the deceased house on that day, these are the words that the first accused person said. And I've quoted them verbatim. In reference to another country where they account for everybody, not like in Kenya, where you can come and do something and just disappear, and someone can impersonate, since we don't have a database. In reference to another country where they account for everybody, in Kenya, you can come do something, just disappear, or impersonate somebody, since we do not have a database. And then, of course, Owen says he identified him on the parade. I'll come to the parade. Other than the evidence of Owen, I sought to find out whether there's any other evidence that would place the accused person maybe in the deceased house. And I came across the evidence of PW25, Chief Inspector Frederick Ngahu. Attached to the Directorate of Integrated Command and Control Center, and he brought records of the movement of vehicle KCA E03E, the second accused vehicle which the first accused person was using, had indicated, without me having read in details, that this vehicle was within the subject's time and the set time within the Dennis Prit area. And that is within the vicinity of the commission of the offense. And so, it is the finding of this court that There is evidence the first accused person was within the vicinity of Dennis Street area, the vicinity of the commission of the offense, and that corroborates the evidence of Lee Owen of his presence in the house of the deceased. But I have looked at his submissions about the two male and the unknown. And I took time to think about this. And this is my findings and my observation. That we are talking about DNA on straps. And I'll repeat that. We are talking about DNA being found of male on the straps. We are not talking about DNA on the body of the deceased. Hear me out. Straps have taken judicial notice of the fact that there are items that can be purchased from a departmental store. And they can be handled by more than one person. The seller, the buyer, and the end user. And therefore, the possibility of DNA of more than one person being found on these straps is not far-fetched. It's not unimaginable. If we are saying that this DNA was on the body of the deceased, it would put beyond reasonable doubt that those people were in that house and had contact with the deceased. In any case, may I take all of us back to the particulars of the charge? They say, jointly charged with others not before the court. I say no more. But finally, before I move out of that area, the question that we must ask ourselves is, does the fact that there may have been other people who are still at large exonerate the first accused person from blame? My answer was in the negative. Was the first accused person the last person to be seen with the deceased? The doctrine of last seen was discussed in the case of Kimani versus Republic, where the Court of Appeal said this, and I will read it because it's important. The doctrine of last seen alive is based on circumstantial evidence where the law prescribes that the person last seen with the deceased before their death was responsible for his or her death, and the accused is expected to provide an explanation as to what happened. In the Nigerian case of Archie versus Tet, 1993, the court relied on the case of Eastman versus Tet to discuss the doctrine of last seen. And this is what the court said, and I quote, "In the case of culpable homicide, as is in the present one, where the doctrine of last seen has been applied, the law presumes that the person last seen with the deceased before the death was responsible for his death, and the accused is expected to provide an explanation of what happened." The last seen doctrine stands as negation. I will repeat again. The doctrine of last seen stands as a negation and an exception to the doctrine of presumption of innocence. It is therefore tried law that where a victim was last seen by the accused and is found dead, the death of the victim will be presumed, and it will be presumed that the last person he was last seen with is responsible for his death. Therefore, if the first accused person is the one who was last seen with the deceased herein, as testified by Lee Owen, then the first accused person will have the burden to explain what happened to the deceased. Please have a look at the case of Achbong versus State, 2006, LCN. You'll find it in my judgment. It is the finding of this court that the first accused person was in the deceased house on the material date. And he was the last person to be seen with the deceased. The evidence of the protected witness is that Harun, whom he identified on the parade as the first accused person, left that house at 23, that's about 11, and no one else went to that house. It is the evidence of this witness the deceased Sudanese boyfriend was not in Kenya. And there is evidence that this deceased person was supposed to be traveling the following day to go to Dubai to meet the Sudanese boyfriend on business and holiday. The next issue I'm considering at this point is whether the first accused person had a gun on the material date and whether he used it to subdue the deceased. May I have a little more water? The evidence of Brian Kasaine's Peter, corroborated by the evidence of no other person than the first accused person himself, is that by 19th of September 2018, the first accused person was in possession of a gun. That gun belongs to Brian Kasaine Spira. And so, it is undisputed that on 19th of September, the first accused person was in possession of a gun belonging to Kasaine, PW17. In fact, Kasaine testified that the first accused person had earlier on borrowed this gun to go on what he said a refresher training, returned it, and then he borrowed it again. And according to Kasaine, and this is important, he was supposed to return that gun after 2 days, but he did it. And so, by 19th September, he had a gun. That corroborates the evidence of Jennings that when they left Roadhouse, the first accused person opened the dashboard of the car and removed the gun after putting a white council on top of his cloth and picked a taxi and went where he was going. And so the question is this: if he was armed with a gun and the gun was not used to kill the deceased, what was it for? I am in concurrence with the submissions by the prosecution that the gun was intended and used for the purposes of subduing the deceased. I'll quickly move to the identification parade. The identification parade was conducted by Chief Inspector Arama. Again, I'm fast tracking, so I'll not go through the rules of a parade. There were witnesses when I looked at the identification parade, and critically so, I noticed the following. One, the identification parade listed 4 witnesses who I do not understand how, but anyway, is there, included the investigating officer. But the investigating officer then was not given an opportunity to go to the parade, but he's indicated as a witness. As I told you, I looked at age and everything, that I needed to look at. And the identification. It is notable that the first accused person did not sign on that form where he was supposed to sign to confirm that he was satisfied with the parade. Secondly, it is in evidence that PW7, and he admitted Owen, before he went to the identification parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade and for the benefit of the office of the DPP, join me in the words of the court in David Mwitawanja and Others versus Republic. Quite good read on identification parade. And this is what the court said. The purpose for and the manner in which identification parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud. And therefore, this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade per se. The last question is whether this first accused person committed the offense. And I'll pick on issues I raised and that I've not dealt with, so I'll not repeat what I've already dealt with. The first argument of the first accused person is that he can't have committed an offense in 10 minutes, and that is what I want to address now. is that he can't have committed an offense in 10 minutes, and that is what I want to address now. And that brings in the issue of contradictions on the time Haron entered and exited from the house of the deceased. It is not in dispute that the entry in the occurrence book at Ramuria Gardens indicates that Haron entered the premises at 23:21 and left at 23:31, 10 minutes. That is not in dispute. And the prosecution explanation to the same is that the entry in relation to what time Haron entered the house is erroneous. That is an error. So I took a journey. I'll tell you the journey I took. My journey started with Jennings. Jennings states that they left Roadhouse with the first accused person at 8 p.m. Right? He goes on to state that he then went to a petrol station after the changing of clothes. I've spoken to that, where the first accused person left him waiting with instructions that if the second accused person needed the vehicle, please give it to her, and took a taxi. According to Jennings, by the time they were parting with the first accused person, it was 8:30 p.m. Then we come to the evidence of Lee Owen, who then says when he arrived in the deceased house at 9, the first accused person was there. Now look at this evidence. Lee Owen says, in fact, he says, I entered when the 9 o'clock news were on. And the entrance is saying he entered 23. So let's just continue this journey. They leave Roadhouse at 8, they part at 8:30, and by 9, according to Owen, he's in the deceased house. Then according to Owen, he leaves the first accused in the deceased house. But even departure from the first accused house does not seem to an issue. So the question I've posed for all of us to ask and answer is, if this first accused person left Jennings at 8:30, and by 9 he was in the deceased house, is it possible then the entry that shows he entered at 11 o'clock was an error? The evidence of the timings corroborates a finding that 23:21 was an error because it does not tie with the movements and the evidence of the witnesses. And so for me, my finding was the argument that I couldn't kill in 10 minutes is not tenable. And I pose the question, if indeed the first accused person, before I even pose that question, I have made an observation that this court visited the scene. This court had the benefit of seeing and monitoring and appreciating the distance from Roadhouse to where the deceased was staying. Less than 15 minutes walk. And so if really indeed this first accused person left Jennings at 8:30, he would not have taken more than 15 minutes to be in the deceased house. And that corroborates the evidence of Jennings. By 9 o'clock, he was in the deceased house. And so my conclusion is the argument about 10 minutes, not tenable. Now, the forensic evidence. Evidence has been produced in this court that the shot which was collected from the house of the first and the second accused had blood stains. Subjected to forensic exercise, it is the evidence of the prosecution that the blood on that shot was the deceased blood. Lots of issues are also on that shot. Is it the shot that was collected from the accused house? The accused says no. I ask myself as a court, so are we then saying the police went and bought a shot? Are we saying the police substituted? If they did, where did they find the blood of the deceased to put? Then the accused person advances a further argument. Surely, if there was blood, it should have been seen. I go back to the evidence of the analyst, and he says, and I quote, I think, if I can get it. Yes, here we go. My paragraph 212, my judgment. In cross-examination by the first accused, the analyst stated that the blood stain on the shot was a small spot on the front. A small spot. So one asks, if I were to pick something, was it then generally visible that the scene visiting officer who took a photograph of it, the people who are collecting it would have said, oh, this one has blood. He said it was a small spot. Then there was a question on the storage and the chain of handling. And this is what the witness said, that all XBs are kept in high security cabinet, and this was kept in the high security cabinet marked JKZN. Okay? And in my finding, and it is the finding of this court, no reason has been advanced why the investigating officers would have done away with the shot which they collected from the accused house, find a different shot, subjected to forensic examination, and is found to have the deceased blood. It is my finding that this shot, which was taken to the garment analyst for forensic examination, is the same shot which Pamela, the house help, has identified, is the same shot which Jennings, who was at Roadhouse with the accused person, has identified, is the same shot Chelagat, who was with the accused on that day, has identified, is the same shot which is entered in the inventory. At this point, I want to go to the evidence adduced against the second accused person. I don't need to replay what the state and the prosecution said. I've already spoken to it. But I want to bring in the evidence of the second accused person and the submissions. It is her evidence, and the submission is that I did not know the deceased. It is her evidence and the submission that I had no reason to kill her. In fact, she says in her submissions, if I knew, leave alone killing, that there was a plan to kill her, the conscience of my banks would not allow me to keep quiet. I would report. She says in her submissions, yes, my phone went off, but says, my phone going off is not commission of a crime. And it was not switched off because I was committing a murder. She says in her evidence and submissions, I gave the first accused persons the vehicle. Yes, it was my vehicle, but I have no control over it when he has it. She says in her evidence, no forensic, no data, no eyewitness places me at the deceased house on the material date. She says in her evidence, the people who visited the deceased were of male gender. I'm of a female gender. And no one has said there was a lady who visited the deceased on the material date. She says, I've explained where I was throughout, from the time I reported to work, to the time I joined the interview of the former governor, to the time we went to Q launch, and then went to 40, to the time I went home. It was the duty of the prosecution to displace my alibi. They have not. And she says, if they're asking this court to convict me for aiding and abetting or an access, there's no evidence I did. And if there is any evidence of anything I did, it has nothing to do with the murder. It could have something to do with the shooting incident. And tells and analyzes and crashes and says, the murder was on 19th, the shooting incident was on 20th. The murder was by a sharp object, the shooting was by a gun, excuse me. And so they are not related. I am not accessory after the fact. I will not read for you, it's an accessory after the fact. I will not read for you what the sections on aiding and abetting. You will read it for your own benefit when we come to copy of my judgments. As I read, I see a few errors, you have them corrected. And so for her, the sum total of evidence adduced, either through oral or documented evidence, does not show that she was involved in the murder in any way. She says again, I did not witness the burning of any cloth, and then goes on to say, if anything is the case anyway, the clothes were burnt in a public place, and the investigating officer did not establish whose place it was. Then finally says this, my relationship with the first accused person, and she says, then, my relationship with the first accused person then was that of cohabitation. And aiding him to get treatment after he was shot. It's a constitutional right under Article 43. If anything is the case, you can't take a gunshot wound lightly. She says, by any stretch of imagination. She then crowns her submissions by coming to the doctrine of last say and says, if there's anyone to be asked as to what happened to the deceased person, it's the people who are last seen with her, who are Waridi, Kaka, Owen, and the first accused. Let's look at the evidence. The defense by the second accused person is an alibi defense. The law is settled. One, it must be raised at the earliest. And two, it is the business of the prosecution to displace it. So when the accused person says, I woke up in the morning, I did 1, 2, 3, and removes themselves completely from the commission of the offense, it is the prosecution to say, no, you did, what you're saying is not true, you are. And let me tell you why that is the law. Please join me with the case of Kiari versus Republic 1984. This is what the court said. An alibi raises a specific defense. And an accused person who puts an alibi as an answer to a charge does not in law thereby assume any burden of proving that answer, and is sufficient if an alibi introduces into the mind of a court doubt that is not unreasonable. All right? But it suffices to note that relying on an alibi defense, the entirety of the prosecution evidence must be considered, either direct or circumstantial, so that the court is appraised to establish whether that accused person was elsewhere and not at the scene of crime. Further, the conduct of the accused and the decision to raise an alibi during the defense hearing case, if that be the case, should not escape scrutiny of the court. Adedeji versus State, failure by the police to investigate and check liability of alibi would raise reasonable doubt in the mind of a tribunal and lead to the quashing of a conviction imposed. Ricky versus State, Free State High Court, the acceptance of the evidence on behalf of the state cannot by itself be sufficient for rejecting alibi evidence. Something more is required. You can read more on that. My last few pages will be dealing with the conclusion, but I want to take a tour, because at this point I posed a question: was the second accused person involved in the commission of this offense? I said, hold on. I have then moved to discuss an issue that has played in this matter and has been identified as distinct from the matter before the court, and that is the gun shooting incident. So let's move to the gun shooting incident. By an OB, number 79 of 21st of September 2018, produced in this court as prosecution exhibit number 33, the first accused person reported at Langata Police Station that while he was going home, Royal Park Estate, he was shot by thugs in what was described as a robbery. Subsequent thereto, he wrote a statement to that effect with the police. Similarly, the second accused person on 28th of September 2018 wrote a statement in support of that report that the first accused person was shot by thugs while going home. 28th September, I've had the benefit of that statement. It's marked as prosecution exhibit number 109. I have read it in its entirety. It suffices to note this. On 29th, the following day, the second accused person writes yet another statement on the shooting incident and retracts what she has said in the statement of 28th of September 2019. This time her evidence and her statement is that no, he wasn't shot at the gate. It's an incident that took place in our house. Now, Brian Asaine Spira, the owner of the gun, testifies that while asleep, The first accused person went to his house groaning in pain and said, "Oh, Brian, please rush to my house and secure the gun." Remember, the gun belongs to Brian. He's given it to the first accused person. The gun has fired or been fired or whatever. So Brian rushes to the first and second accused house and secures the gun. What does he say about his observation? He says, "I found blood on the floor. And that when the first accused person came to my house, he had blood all over the chest." Who else speaks to these events? The house help. She says that she had noise, and when she went to check, she found blood, she found a gun, and her concern was, first of all, to secure the child from that scene. But she says she saw blood. There is evidence of PW27. Eunice Mohammed, who was the caretaker at Royal Park Estate, he says, "No, if there was a gunshot incident at the main gate, I would have known as a caretaker. There wasn't." Kasaini comes back. Remember, Kasaini was a neighbor to the accused persons, and he says, if there was a gun incident in our estate, ingewekwa kwa mtandao ya estate association WhatsApp group. It wasn't there. What does that say? It is the finding of this court that the report made to the police by the first accused person, the statement made by the second accused person on 28th of September was false. The first accused person expressly admitted he lied in his evidence in this court, before this court. Now, what is informing this lie? It is very clear that Brian Kasaini had given the first accused his gun without authority. And so according to Brian, when he realized that his gun has been used, his first concern to the first accused person was, "What are you going to do?" And the words of Brian in his evidence is that the first accused person told him, "Do not worry. I'll take care of that. I will report it as a robbery." Now, let's look at the legal, natural, probable, and moral consequences of a lie. The case of Kinuthia versus Republic, 2003, the Court of Appeal had this to say. I will repeat. Kinuthia versus Republic, 2003, EKLR, the court had this to say, I quote, "Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness." I will repeat. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. The court went on to say, in a criminal case, a witness should not create an impression in the mind of the court that is not a straightforward witness. That if a witness raises suspicion about his trustworthiness or does something which indicates that he's doubtful, he has doubtful integrity, he will be deemed to be unreliable, which makes it unsafe to accept his evidence. Please also look at these other cases. Dungu Kimani versus Republic, MTG versus Republic. My analysis of the evidence. In relation to this issue of giving false or denial, the first accused person says, "I'd never met the deceased." Court data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, I say in Emali, evidence reveals the contrary. The first accused person gives the reason why he's wearing a kanzu and says, I'm going to meet people in Isli, from Muslim community. He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back. And in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. The first accused person asked Kasain to give him a gun for training. The gun is found, evidently, at the time the offense is being committed, at the scene of the offense. And of course, his own confession, I lied about the gun shooting. The second accused person contradicts her own statement by the statement of 30th and says, 29th, now I'm clear in my mind. The statement I gave you yesterday was a lie. Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last tale of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, look at all these contradictions in the case of the prosecution and find that the prosecution have not proved their case beyond reasonable doubt. The case of John Yagan Jacque and 4 others versus Republic. The court says this. In certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. I'll read again. In certain criminal cases, particularly those that involve many witnesses, discrepancies are in many instances inevitable. Philip Zioka Watu versus Republic. Court of Appeal had this to say on contradictions. However, it must be remembered that when it comes to human recollection, not witnesses recall exactly the same thing to the minutest detail. Some discrepancies must be expected because human recollection is not infallible, and no two people perceive the same phenomena exactly the same way. Joseph Maina Mwangi versus Republic. Lays the legal principle that the court will not disregard the evidence of a witness on the ground of contradictions unless the contradictions go to the root of the case and create doubt as to the guilty of an accused person. And the court had this to say on that. In any trial, there are bound to be discrepancies. An appellant court, in considering these discrepancies, must be guided by the wording of Section 382 of the Criminal Procedure Code, where such discrepancies are such as to cause prejudice to the appellant, or if they are inconsequential to the conviction and sentence. What are these contradictions this court has been invited to look at? Contradiction on the time Aaron went to the house of the deceased. Contradiction on the cloth. Some people say he had a kanzu, others didn't say he had a kanzu. contradiction. One witness said, I saw him with a bag. Another one, I didn't see him with a bag. In my finding, and it is the finding of this court, the contradictions the defense has invited this court to look at are inconsequential. They do not go to the root of the matter, and the evidence of the witnesses cannot be disregarded on that ground. I am expected to be bringing the curtain down, but I'll go to the last ingredients, those of us who are working with me. And I have to pose a question and answer at this point. Then I'll come and answer that question. And I will repeat the question. Did the first and second accused person kill the deceased? I will answer it. But if, before I answer that question, let's look at the last element of malice aforethought. I'll look at two things, then I will close. I'm sure you're wondering what is the next thing she's going to look at, so let me whet your appetite. I'll look at malice aforethought, I'll look at circumstantial evidence, then I'll close. I'm sure the lawyers understand why this judgment had to be this long. There was no option out of it. Please join me in looking at section 206 of the Penal Code. And just to save a bit of time, I will not read because I've captured it from the law. Please allow me not to read, I pass. But it talks about malice aforethought shall be deemed to be established by evidence proving any of the following, then it gives the circumstances. Please allow me not to read. But maybe I need to just point out subsection C, an intent to commit a felony. So you'll be deemed to have had malice aforethought if your intention was to commit a felony. Now, in the instant case, what the prosecution are arguing is that even before the day of the murder, the first accused person had already started preparing, premeditation. And so how do they support their submission to that effect? We go back where we were earlier. Look at his conduct before. Look at his conduct during, and look at his conduct after. So let's just do a recap. The first thing is that the first accused person, and I made a finding on that, and we don't have to belabor it. The first accused person stole the ID of Dominic Becerra Harun on 17th of September, 2 days before the murder. And why this court has arrived at the conclusion that he stole the ID is because of two things. One, he resides within the Royal Park estate where the ID was stolen. Is it a coincidence? Number two, the ID was never recovered. The owner had to get a duplicate. And number three, the witnesses to whom he presented that stolen ID have identified him on the ID parade as the person who presented the ID. So it's not hard to join the thread. And my finding is that the first accused person stole the ID of Dominic Becerra Harun 2 days before the commission of the offense. Secondly, the evidence analyzed reveals that this first accused person, other than the cloth he was wearing, he carried a bag, and the house help has testified that he had a bag. That evidence of the house help has been corroborated by the evidence of Jennings, whom he joined and who was his friend. And Jennings says, yes, he had a bag that he removed a counsel. So the question is, why didn't he wear a counsel right from the time he left home? Does the carrying of the counsel to be worn just before the murder and removed immediately the murder part of the plan? Does it constitute malice aforethought? Number 3, it is evident that he had borrowed a gun from Kasaini. He was supposed to return the gun after 2 days. He didn't. Then just before he went to the deceased house, he took the gun and went with it. Does the fact that he borrowed this gun even before the due date or the material date or the fateful night part of his plan to commit the murder? The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it, but in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number 5. The evidence of Janice is that he was left waiting for the first accused person at a petrol station. Earlier on, when they're having drinks and food, they were discussing about setting up a security firm or company. He says that when the accused person, before the accused person left him waiting, he told him, I'm going to meet, he spoke about a girlfriend who was coming from South Sudan. And he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated. He was not in the mood and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. I picked this from the post-mortem report, that the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now, this brings me to what played before this court heavily, as I had this case. On very many occasions, and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have you
Join us every Friday from 8 p.m. to 9 p.m. for a captivating journey into the world of love, relationships, and romance, presented by the dynamic trio of Maggie Jones,
however,
MC Jesse, and Annie Maribe.
But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion.
For you.
Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. I picked this from the post-mortem report, that the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now, this brings me to what played before this court heavily, as I had this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have you arteries and the veins that were injured are severe or the cut and no blood is supplied, and the victim cannot consider it. I considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only. Occasioned by a sharp object. It is my considered opinion. The target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Does this connotes malice aforethought? I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation. It's no wonder then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. It's not a person who has no training in military terms, because the way it was done in such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses, and I'll start with the evidence of Jennings, when he met the first accused person, there were on a VIP protection exercise, and he said that that is when the US president was in Kenya. And he says they then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Jowie. Here's the finding of this book. That for one to engage in VIP training, they definitely must protection for training. And that training will not be too far away from the training of an. And if the first accused person went through this and he murdered the deceased, then he had the law. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence the first accused person told me, forget about it. They won't have it. I don't know. I have a private company for you. What does that statement speak to? He says, look, the person whom the deceased allowed into her house was Dominic Becerra Harrow. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Haron, the deceased would not have contradicted that because the deceased also introduced him as somebody who works at State House. So we all know that, hopefully, the court is making a right observation, I think I am, that people who work as undercovers will not quickly volunteer their true identity. And that could inform why, even when he said I'm Haron, and the deceased knowing whom he has said he is, would quickly say, let Haron come in. And then in the house gives him his true identity to the other persons in the house as well. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. cases that speak to circumstantial evidence. Some very critical areas, I think, will guide my findings. Ahmed, Mohammed, and another versus Republic 2019 speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given emphasis, my own emphasis, on the following. It works by culminatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, it is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense, armed himself with a gun, carried a counsel, put it over his clothes, went to Ramuria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken culminatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case, the first accused, I'm still on the first accused person, committed that offense. It was not a case of homicide. Excusable homicide, it was unlawful. And therefore, I find the first accused person guilty as charged. hearing of the offense of murder that on the night of 19th of September 2018, at an unknown time at Ramuria Gardens apartment, Hitare Lane off Dennis Street, with others known before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day. Only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause or knowing it to be likely that he will thereby cause the person employed in public service A, to do or omit to do something which the person employed in public service ought not to do or omit, if true state of facts respecting which such information is given were known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there any offense committed when the second accused person gave a statement to the investigating officers at Langata Police Station, which turned out to be not true. I say no more. The Office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Nyawira Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We move to the next stage. The state you are supposed to go next.
Yeah, the first one.
So I am expecting the records. Ibene,
You'll be asking for nothing. To present CFO to the previous records for the first accused person. This has been convicted. In the meantime, you also be asking for a presented report in relation to the first accused. And you also say that the first accused during the mandate that I don't really want. Actually, I will explain the serious condition and also the serious sentence report. We also pray for high copy of civil sentence.
may I know whether Professor Nando, you have anything to say?
Yes.
No, the victims probably in the same story.
I don't have anything.
Professor Nando, yes. Professor Nando, for the first accused person, you have something?
Yes,
to
sure.
say?
Your Honor, first of all, we appreciate that this kind of report this conclusion. We do pray that we be given time also for us to prepare some investigation. We also endorse the city indictment of this kind of report that it maintains the plain terms were granted to refer to the first accused person conduct is not reflected. We will again be saying in situation when required. We also pray that the next is what the other items that was which are personal in nature, even the case completed, the towns, specifically forms. That's
My lady, in the last session, we didn't take directions on dressing, so I pray that you excuse me. And dressing will happen.
That's okay.
Thank you. The second thing, and which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really want you to know that we appreciate as it depends your attention to detail. My lady, for the second accused, we want to say, we wouldn't want to have taken it for granted. Sorry for the first accused. We are grateful for the acquittal on the time that she was facing. And we pray, my lady, for release of the securities that have been put in to study inside.
You are asking for the release of security?
Yes, we are praying for.
That is surety?
Yes.
Well, you realize when this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court?
We can go.
I think it's administrative.
Yes.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
And they do not intend to appeal.
I do not know where you get that from. I don't know. That I'll leave to you.
Yes.
But of course, if they are not, after 14 days, you can seek for release.
Okay.
We need to give them the 14 days. Okay?
My lady, that's on behalf of the second accused. Thank you very much.
Okay, so a matter of this nature, you cannot afford to pronounce a sentence without, of course, a Maribe report, because it is that report that will take into account the views of the victim's family. And so we will start over this matter to another date when we'll be dealing with the sentence. It will also allow the prosecution an opportunity to seek for CRO, those are records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of. And it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant. We take a date for dealing with the sentence. Diary. It's not my diary. Now, as I had indicated earlier, I'm starting my leave on Monday. I think, Professor Nando, you are aware of that because there are other matters that you have before me. And so, just to guide you, I'll be away from the 12th of February to Assistant. You don't have a diary where I can just quickly pick 24 February. 11th of March. You'll be before me on 12th.
No, I'm
On 11th. Okay, so you want us to give you the 12th of March?
yes.
You have two other matters that are coming for judgment before on 8th of March?
Yes.
8th of March.
8th of March. Can you make it on the same day?
Okay.
You are also coming here.
Am I coming here?
Yes, 8th of March.
Yeah, it's a Friday. I come here on a Friday. Okay, 8th of March. Yeah, okay. I thought we are dealing with those matters virtually, Prof. You want me to come here? Okay. That's okay. I can. Okay. May I have the first accused person stand up? You will appear before the court on 8th of March for sentencing. Unfortunately, after conviction, I'm unable to accede and or allow the prayer by your counsel for you to remain on bond. I'm canceling your bond. You'll be held in custody until the 8th of March. Okay? So that is done. Assistant? There's another file with So, as I adjourn court, may I take this opportunity once again to sincerely thank the first accused person, please sit down, the counsels who've been involved in this matter. We've had dedication. I don't remember how many times this matter was ever adjourned because the counsels were not there. I do not remember how many times, probably the last time the matter was coming for judgment when the accused persons were not there. The state was always in attendance, and we've only been able to deliver this judgment because of that support that I got from the counsels on both sides. I want to thank you sincerely for that support you gave the court and, of course, the commitment. There are things that I will not want to speak to, but which, of course, we all know. But our general statement is always good to respect the court and just give the court its due respect. We don't sit in this court as in our personal capacity. I believe what I see behind here speaks to the authority of the court. And in most times, the court will not have an opportunity to respond to certain communications. The last bit of it would be me. And throughout this matter, I knew clearly what my purpose was to deliver judgment and not to get myself into response to social media or otherwise. And that has nothing to do with my decision. It has everything to do with a plea on my own behalf and on behalf of my colleagues and the entire judiciary. Let's support the judiciary. When a matter is still in court, it's just good to allow that matter to be dealt with. Any comments that would probably be adverse are not necessary. Please, Kenyans, support the courts. I'll leave it at that, okay? Otherwise, press, asanteni sana kwa kuja. When I called the parties to come before me on Wednesday and said, are you ready for this judgment? I knew the press had left knowing we are coming on 15th of March. Hope I didn't surprise you. But from the population I'm seeing here, I think information reached you in time. And as I'd said, please, for those who may not be able to come to court, make it online. And I'd been assured that we'll have an online, but nothing lost. The most important people who needed to be present are in court. So asanteni sana kwa kuja. And finally, thank you for being patient with the court. My judgment is about 117 pages. And it may not take one day to write. Okay? If you want to know my workload, please visit Naivasha. You will understand. So for me to come up with this judgment, I don't want to praise myself, but sometimes it calls for quite a bit of work going into it. So I'll just say that thank you for being patient with the court, and I do appreciate the indulgence. Thank you. Yes, Professor, you want to say something?
Yes, my dear, I wish to intervene for that.
Naam, so dakta mtazamaji, kama unavyoona tumekuletea matangazo hayo moja kwa moja kutoka mahakama ya Milimani hapa jijini Nairobi, na hatimaye mtazamaji, haki imeweza kutendeka dhidi ya familia yake Monica Kimani, ambapo jaji Grace Nzioka ameweza kumpata Jowie Irungu na hatia ya mauaji, na pia vile ameweza kumuondolea mashtaka Jacque Maribe akisema kwamba hakuhusika kabisa na mauaji hayo. Mtazamaji, ni kesi ambayo iliweza kuanza tangu mwezi Septemba mwaka 2018, na katika hali ya kuweza kusaka haki ya Bi Monica Kimani, basi kesi hiyo imeweza kuahirishwa takriban mara 3 kabla uamuzi uweze kuafikiwa siku hii ya leo. Mtazamaji, kama unajiunga na sisi kwa hivi sasa, ni kwamba Jacque Maribe ameweza kuondolewa mashtaka ya mauaji, huku Jowie Irungu akipatikana na hatia ya mauaji, na vile jaji Grace Nzioka ameweza kusema kwamba bondi yake Jowie Irungu imeweza
Join us every Friday from 8 p.m. to 9 p.m. for a captivating journey into the world of love, relationships, and romance. Presented by the dynamic trio Maribe, MC Jesse, and Annie Waweru. Bed of Roses promises to be your weekly dose of heartwarming stories, insightful discussions, and expert advice on matters of the heart. Whether you're single, in a relationship, or simply love a good love story, this is the show for you. Don't miss out on the chance to unwind and indulge in the joys and challenges of love, all brought to you by our talented hosts. Tune into Africa 24 every Friday from 8 p.m. to 9 p.m. and let us guide you through the enchanting world of Bed of Roses. Subscribe now and mark your calendars. You don't want to miss this. See you there.
I would have liked to know from Mr. de Klerk, who was disciplined when 8 million of taxpayers' money was given to Inkatha Freedom Party? That was in July 1991. Who was disciplined? These vague statements are counterproductive because they lead to the conclusion that Mr. de Klerk is less than frank in making important statements on national issues. But I want to say that various points of view have been expressed here. I wanted to assure you that on the 27th of April, you will make your choice. And I don't doubt what it is going to be. I would have liked to know from Mr. de Klerk, who was disciplined